In most mediation processes, the parties will be asked to prepare some kind of written submission in advance. This is a place where you, as their attorney, can lay out the facts and the law that pertain to the case. But there's more that the mediator may ask in advance. There's more that you can offer so that you can take the best advantage possible of this process. We can talk about what settlement objectives people have tried in the past, what, if any, barriers have existed that are getting in the way of the parties themselves being able to resolve this, and what is the major concerns that parties might have. What does your client want to achieve? What barriers have you seen that are getting in the way of achieving that? Is there any specific assistance you want from the mediator that would help you work more effectively on your client's behalf? If there are things about your side or your client that you cannot reveal to the other side but that are getting in the way, it's actually helpful if the mediator knows about that. Every settlement discussion, every problem resolution process always is done in the shadow of what happens if this doesn't work. So in your preparation, thinking through on your own as a lawyer or with your client, what happens if we're not successful in achieving the kind of resolution that this process is hoping for? If we're not able to achieve a settled resolution, there's going to be continued expense, there's going to be continued hassle, there's going to be continued time commitment, there's going to be continued worry about risk. And those things need to be on the table. Some of the preparation work that is necessary for this process is all of the preparation work that you would do for an adversarial process. You need to know your client's facts and law in and out. There's more. You also need to know, what does your client need? What is your client trying to achieve? What will make a settlement happen? If you only convey to the mediator the facts and the law, you're not using this process and this service as effectively as you can. There may be some stuff that feels not fully appropriate or not fully safe to put down in written submissions. But there may be reasons why a more informal conversation or something that is not reduced to writing feels more appropriate. There's nothing inappropriate about speaking privately or individually with a mediator. If there's things that you want to tell a mediator privately, call them, talk to them, tell them what they need to know. The more information you can give the mediator about what you need and about what you think the other side might need in order to move beyond just saying, yes, we have a dispute, but instead move towards saying, yes, we can resolve the dispute,